Thank you for joining us this afternoon at the Heritage Foundation in our Douglas and Sarah Allison Auditorium. As we do begin, we would ask everyone in-house to make that final courtesy check that your cell phones have been turned off. We, of course, welcome comments and questions from our internet viewers at any time. Simply email us at speaker@heritage.org, and we'll be glad to include them in the program. We will, of course, post the program within 24 hours on our website as well for everyone's further reference. Hosting our discussion this afternoon is John Malcolm. Mr. Malcolm is the Ed Gilbertson and Sherry Lindbergh Gilbertson Senior Legal Fellow, as well as Director of our Edwin Meese Center for Legal and Judicial Studies. He is also Chairman of the Criminal Law Practice Group of the Federalist Society and serves on the Board of Directors of Enough is Enough. Before joining Heritage, he was General Counsel at the U.S. Commission on International Religious Freedom, as well as a distinguished practitioner in residence at Pepperdine Law School. He has served as Executive Vice President and Director of Worldwide Anti-Piracy Operations for the Motion Picture Association of America, a Deputy Assistant Attorney General in the Criminal Division at the U.S. Department of Justice, a partner in the Atlanta firm of Malcolm & Schroeder, LLP, as well as a United States Attorney in Atlanta. Please join me in welcoming John Malcolm. John?
Thank you all for coming, and welcome to the third program in our Preserve the Constitution series. I commend them all to you. Well, it's another term is upon us at the Supreme Court, and as usual, they all seem to be action-packed in one way or another, and we have two very distinguished Supreme Court practitioners here to discuss a number of these cases. I could give them the introductions that they both deserve, but that would take up our entire hour, so I will be brief. And then I think what we're going to do is have a little dialogue on stage about some of the cases that will come before the court this term, and then we will be sure to leave some questions from all of you. So to my far left, we have John Elwood. John is a graduate of Princeton University and Yale Law School, and also has a master's degree from King's College. He clerked for Judge Daniel Mahoney on the Second Circuit, and then for Justice Anthony Kennedy. He worked in various divisions at the Department of Justice. He was in the Criminal Division, the Office of Legal Counsel, and also in the Office of Solicitor General. He has briefed and argued over a dozen cases before the High Court. He is currently a partner in the appellate section at the firm of Vinson and Elkins, and when he joined the firm, Chambers USA reported that he was going to be an immediate enhancement to the firm's appellate practice because he, quote, is much loved and widely respected lawyer who is quick on his feet. To my immediate left is Paul Clement. Paul is a graduate of Georgetown University and Harvard Law School. He also got a master's degree from Cambridge University. He clerked for Judge Lawrence Silberman on the D.C. Circuit and then went on to clerk for Justice Antonin Scalia on the Supreme Court. He served as the chief counsel of the U.S. Senate Subcommittee on the Constitution, Federalism, and Property Rights, and then he spent during the last administration 3 years as the principal deputy solicitor general under Ted Olson, and then succeeded him and served for another 3 years as the 43rd Solicitor General of the United States. I believe Paul has argued, if I'm getting this number correctly, 69 cases in front of the court, including several landmark cases. He is currently a partner in the law firm of Bancroft PLLC. Before we get started, please take a moment and join me in welcoming our guests. So, Paul, the first case I'd like to talk about is Bond versus United States. Now, this is your second time before the Supreme Court in this very unusual case involving a vindictive woman named Carol Ann Bond. You prevailed the first time on the standing issue before the court 9-0. And so she was given standing to challenge the federal statute in question. And now you're up before the court again. What's this case all about?
Sure. Well, thank you, John. It's great to be here. I should say I don't think it would be a Heritage Supreme Court preview without talking about the Bond case. I know we talked about it last year, and I think we may have talked about it one other time, because as you suggested, it's been before the court one other time. We have many distinguished people in the audience, but I have to recognize one of them, Walter Weber, who is an important part of why the bond case made it to the Supreme Court, certainly the first time, which is he sort of ran into the practitioner who'd been working on the case in the lower courts, and the practitioner was about to let the time go on the cert clock, and sort of suggested whether Walter knew anybody who might possibly be interested in this case. And Walter reached out to me and one or two other people, and we took it from there. So I wanted to acknowledge that. Great service I think Walter did to the bar, because by getting the case up there once, we at least now know what I would have thought we would have previously known, but the Third Circuit had a different view, which is that you actually do have standing to argue that the statute under which your liberty is being deprived violates the Constitution. So the court established that the first time around 9-0. Now it's back on the merits, if you will. And, in defense of the Third Circuit the first time around, the reason it reached the result that an individual did not have standing to argue that they were being convicted by a statute that violated federalism principles or the 10th Amendment is that the Third Circuit sort of relied on an old chestnut, a case that at least arguably stood for the proposition that only a state could raise a 10th Amendment objection. And it's kind of deja vu all over again, because on the merits, the Third Circuit again relied on another old chestnut, this one, Missouri against Holland, which is a case from the 1920s that the parties debate what it actually stands for. It has been understood in some circles to stand for the proposition that if Congress is implementing a valid treaty, whether it's a self-executing treaty or a non-self-executing treaty, usually Congress passes statutes to implement a non-self-executing treaty, that if Congress is enacting legislation to do that, anything goes. The kind of normal limits of federalism do not apply. And the Third Circuit applied that principle to say that Ms. Bond's conviction was valid, and at least one of the issues in front of the court is whether that understanding of Missouri against Holland is correct. And we can talk about the specifics of the statute and the specifics of what Ms. Bond did, but I think in trying to understand why this is important, to take a step back, I think it would be one thing to think of Congress's power to implement treaties if you had sort of an 18th century view of what a treaty could cover. I mean, if the only things treaties are covering is, treaty commerce and amity with France and Great Britain, there's probably not a lot of authority for the federal Congress to implement those treaties. But when you think about sort of the modern conception of what can be covered by a treaty, which is to say everything, then suggesting that Congress has plenary authority to implement a non-self-executing treaty is, a fairly dangerous, potentially, power to assert to the federal government. Or to put it differently, it certainly seems to be in some considerable tension with the bedrock assumption that Congress's powers are not plenary but are limited and enumerated. So there's going to be a lot of, I think, fight. If you look at the briefs that have been filed in the case, there's a lot of fight over what did Missouri against Holland mean, and if it meant what is often attributed to it, should the court revisit it and overrule it. As with a lot of the big cases in front of the court this term, there's an opportunity for the court to act rather boldly and say something definitively about whether it wants to overrule Missouri against Holland or limit Missouri against Holland. There are also, what you might think of as off-ramps that allow the court to decide the case without reaching kind of the really big, important, meaty issue in the case. And one of those in the Bond case is, we, in defense of our client, have offered a theory as to why her conduct was not covered by the statute. The statute was passed to implement the Chemical Weapons Convention. It is not, to say the least, obvious that an individual's use of chemicals in a domestic dispute really implicates the core concerns of the Chemical Weapon Convention. And so if there's a way to interpret the implementing statute so that it doesn't reach her conduct, essentially the $64,000 question in the case can be avoided. And that's certainly something that we press on the court.
Let's break this down just a little bit. I mean, it's a very important case stemming from a single sentence out of a Justice Holmes opinion involving the migratory bird treaty 60 years ago. So let's assume the court does not go with your saving construction, or alternatively, it doesn't go with the argument that the SG is thrown in at the last minute saying, well, this is really under the Commerce Clause. And suppose it rules against Mrs. Bond under the treaty power clause. So all of these modern treaties involving the disabled, the rights of women and children, other disfavored groups, what would the implications of that be in terms of Congress's power?
Well, I think the implications would be very, very broad, precisely because, as I think we've both suggested, what is conceptualized as being a legitimate subject for a treaty in the modern view is really, a very broad conception. So you have something like the International Covenant of Civil and Political Rights, which, purports to cover virtually everything that's covered by the Bill of Rights, everything that would be covered by a state Bill of Rights, and really everything I think that would be covered by, a municipal, civil rights kind of act. I mean, just everything is in that International Covenant of Civil and Political Rights. And the way that, that the Senate typically has dealt with these very broad treaties is to either reject them or to ratify them, but in a way that makes clear that they're non-self-executing. And so instead of, you can have some treaties that take force by their very terms and have immediate effect and are immediately the supreme law of the land. But especially with these broad modern treaties, it's much more common for the Senate to ratify it with the understanding that, wait a second, this is what it is, but before it has any operative effect as the supreme law of the land, we're going to have to pass implementing legislation. Right. And I think the argument that we make is great. So that implementing legislation, like all other legislation, has to comply with the basic structure of the Constitution and the basic limits on that Constitution. And there are, particularly when you're thinking about kind of classic subjects of treaty, there's going to be ample authority for Congress to implement the treaty. But as to some topics that are covered by these modern treaties, it may be that the federal government can implement the federal aspect of the treaty, and it's left to the state and local governments to implement whatever else might be necessary to bring us into treaty compliance. I mean, that's sort of the theory we offer. But as I say, kind of the alternative is that at the same time that the Senate is ratifying these non-self-executing treaties, it's kind of storing up an opportunity to, have additional authority that it wouldn't otherwise have if the treaty hadn't passed. And, Justice Scalia, I think once or twice in oral arguments has kind of, I think, neatly captured the anomaly there, which would be that, our Constitution is what it is. It has its own mechanism for amending it. And the thrust of the argument on the other side is that whenever a foreign nation, the Senate and the President agree and ratify a new treaty, that you can expand Congress's power.
Right. Right. So both of you should feel free to jump in on any of these cases and offer your thoughts. I don't know whether either of you have any predictions on this or what you think is going to be the key to the argument on this. I don't know if that's something you would be comfortable opining on.
I'm probably a little too close to it. I don't know if...
Well, I predict that he will win, but I don't know how he will win. As Paul alluded to, it's true in this case, and by the luck of the draw, I think one of the organizing themes for this term is that there are a lot of cases that implicate weak precedents, and the court will be confronting how to construe those weak precedents and whether to overrule them. And generally speaking, I'm something of an innocent eye test here because I haven't boned up a lot on Bond. But generally, the Roberts Court is kind of a minimalist court, so they may take one of the off-ramps that keeps them from, carving back too much on Missouri versus Holland directly, and may leave that to sort of separate opinions to start sort of a dialogue on what this opinion means. But it is an incredibly important case because, as Paul says, there's all these, treaties out there that say essentially, things got to be good, and you leave it up to Congress to, say what that means in domestic law.
Let's move on a little bit to another important constitutional case, and that's NLRB versus Noel Canning. John, I'll have you start out with this. So in January of 2012, President Obama bypassed the Senate confirmation process, and he named a number of appointments to the National Labor Relations Board and the Consumer Financial Protection Bureau while Congress was out of town. And he did this purportedly pursuant to his power under the Recess Appointments Clause, and now those appointments have now been challenged. What are the arguments here and what's sort of at stake in this case?
Well, the way this all began was through, in about 2007, the Senate Democrats started having what they call pro forma sessions, which is that meet every 3 days to try to break up what would ordinarily be viewed as a longer recess into small enough chunks that under the common understanding of the Recess Appointments Clause, it wasn't long enough to make recess appointments. And during those pro forma sessions, they'd bang the gavel that lasts about 30 seconds, and ordinarily the order, as the Congress left town, would say, no business is to be conducted. And, ordinarily, to keep this in perspective, this doesn't matter so much for, the executive branch, real Article 2 jobs, because there you have the Vacancies Reform Act, and you have a lot of ability, the agencies have a lot of ability to keep the offices filled on a day-to-day basis. It doesn't apply, though, to these independent, commissions, and it doesn't apply to judges. And so this is a case where the NLRB, you can't use the Vacancies Reform Act there, and the Consumer Product Finance, I can't remember,
yes.
CFPB, whatever order those initials go in, they couldn't fill through the Vacancies Reform Act. And so, they made the appointments there. And unlike a lot of recess appointments where it's not clear that these people do things that can be challenged, all of these appointments, were people who could do stuff that be challenged, and were properly held in the court, challenging the constitutionality of the appointments. There are 3 basic arguments that this case presents. It basically presents all of the recess appointment arguments in one place. The first is whether you can make recess appointments when the Senate is meeting every 3 days in pro forma session. And as an additional wrinkle, as you may know, it isn't even the Senate that is responsible directly or really for the pro forma sessions, because under the Article 1, neither house can go out for more than 3 days without the permission of the other, and the House wouldn't give the Senate permission to go out, and so the House Republicans said, we're going to force you into pro forma sessions to keep Obama from making recess appointments. But it is kind of an additional funny wrinkle to have a body that's supposed to have no role in the appointment process basically forcing the action here. But there are 3 questions. First, there's a question about whether pro forma sessions are enough to scuttle the president's recess appointment power. The government's basic argument is, look, this is a practical clause, and the Senate, as a practical matter, isn't available when they only come in every 3 days. It's one senator pounds the gavel and leaves, and they're not supposed to do any business. And the view on the other side is basically, look, Congress gets to say whether they're in or not. They said that they're still in, so you got to take them at face value, and both of these are massive oversimplifications. The problem with the administration's view, though, is that in the same recess, and twice in 2011 when the recess appointments were made, the Senate passed by unanimous consent during a pro forma session legislation which Obama then went on to sign, and he didn't say, this is invalid, this isn't real legislation. And so, it's kind of at a minimum, it's a bad atmospheric fact. And everyone thought that that's what this case was going to revolve around. That's really what was briefed in the DC Circuit, which was the first of these challenges to get decided. But during argument, they started getting interested in a couple of other more fundamental questions, which we'll get to now. And what the DC Circuit held was basically 2 things. First of all, remember the election dispute in 2000 taught us a whole bunch of terms which we heretofore did not need to know, like the pregnant Chad and the hanging Chad. And the things which you will have to know for this is the difference between an inter-session recess and an intra-session recess, which we're all DC nerds, and so we probably already know what it is, but for those of you who don't, basically an inter-session recess is a recess between sessions of Congress. And so typically it's the Christmas recess when one session rises and there is no Congress in between, and then the next one comes in, and that's an inter-session recess. The intra-session recess is most typically, or the biggest of them all, is the August recess, when this Congress is still in session, but they don't feel like working and they're going home to their district to conduct a perpetual campaign. And the DC Circuit first held that basically the recess appointment clause only applies during the recess of the Senate, which they said was the inter-session recesses. They second, and that was subsequently the Third Circuit and the Fourth Circuit both held, yes, we agree with that basic rationale with some wrinkles. The second thing the DC Circuit held, and they are alone in this, was that the recess appointment clause only applies to vacancies that arise during the recess of the Senate. And I will read the actual language of the clause for this one. It provides that the president shall have power to fill up all vacancies that may happen during the recess of the Senate. And the DC Circuit said, unless the vacancy arises during the recess, you don't get to appoint them. And, you know, there are arguments. I think that this is kind of the stronger textually of the two arguments. But I think that there are counter arguments. For example, if you were to be asked, when did the last vacancy in the office of the vice president happen? I don't know how many of you would say August 8th, 1974, when Nixon resigned. And you might be more inclined, you'd probably actually be inclined to scratch your head and not know the answer. But you might be more inclined to say that it was August to December 1974. Or, you know, when it happened, you know, in the 1860s, whether it was just the day Lincoln was shot, or whether it was the entire 4 years when President Johnson didn't have a vice president. So it's, you know, I think there are arguments both ways, although I think that the DC Circuit's view is probably more intuitively appealing. And let me see. Oh, it is a great originalist case. One thing I will say is that it is a great originalist case in that both sides are really dusting off their law books and citing a lot of original stuff, and I find it absolutely fascinating to read. It's a bad case for people who have allergies to dust mites because everybody is citing all sorts of books that have never been cited before and may never be cited again.
So the DC Circuit sort of reached out to an issue that really no one had raised before, and said that it's not enough that the vacancy exists during a recess, it actually has to occur during that recess. I'm assuming that if the DC Circuit's opinion is adopted, since Congress no longer recesses for months on end, you can always hop on a plane and get back to Washington in no time, that would effectively end the process of recess appointments?
Well, I think actually probably the least disruptive to the present way of resolving this would be to do it under the happens to arise versus happens to exist, because a lot of these people who you're going to be replacing are going to be people of the president's own party, and they presumably would you know, favor the president by resigning when it is convenient for him to have them resign. I think actually, even though that the government, the court reached out, the government only petitioned on the two issues which the DC Circuit itself addressed, intercession versus intercession, and happened to arise versus happened to exist. And the people who won below, Noel Canning, the Chamber of Commerce, asked the court to take the pro forma sessions issue as well. And it may be tempting to the court to decide on that grounds, with the idea being, you know, look, the executive branch practice is actually to about 1823 been that the happens to exist reading is the right one. And since the 1860s, they've been making intra-session recess appointments. But this, you know, we've only had this since, you know, 2011 is the first year that this was done. So surely we must be able to, or 2012, I guess, was the first year this was done. Surely we can exist without it. But I think that current events have shown that, you know, unless the president holds both parties, or both houses of Congress, that there'll be pro forma, that they can be forced into having pro forma sessions. And so if the court holds that pro forma sessions have to be respected, I think that that's kind of the end of the president's recess appointment authority, which, as I say, really only matters for independent agencies and judgeships, which nobody wants to do anyway.
Any predictions on this case?
There you go.
Well, if I could,
Yeah,
before,
please.
you know, just one thought on this case before we get to predictions, which, you know, I think I'll actually stay away from. But you know, there's another way of sort of thinking about this case is, you know, John's absolutely right. This case, in a way that I think the only other kind of recent analog that I can think of is like the Heller case, is one of these like great cases where it's all about originalism. Everybody has to be an originalist because what's the choice? I mean, the court doesn't have any other cases in this area. And so, you know, you're kind of like, you know, dusting off these, you know, originalist sources and these, you know, old dusty attorney general opinions from, you know, the founding era. And it's, you know, it's sort of a fascinating exercise to see the court engage in this sort of unadulterated originalist exercise because they have no precedents to cite. But then he sort of asked the question, well, so why is this? And, you know, there was its own unique reason in the Second Amendment context. But here, you know, there really was sort of an understanding that had arisen over 200 years. And, you know, for the first 100, you know, there was a certain sense that maybe, you know, intra-session appointments were to be avoided. But for the last 100 years, there have been lots of recess appointments. And, the general operating principle had been, fun's fun, but don't get piggish about this.
Right.
And, and then, and obviously there's plenty of blame to go around here, and both sides sort of escalated things. But I think it's worth kind of, understanding that I think the reason this case kind of came to the fore is really two things. One, there was this otherwise fairly obscure Supreme Court precedent from a couple of years ago called New Process Steel that definitively held that the NLRB cannot act unless it has a quorum. And that put a lot of pressure on appointments to the NLRB, and the NLRB, especially under the current administration, is wielding a pretty big stick. So that's, I think, part of what's going on here. But the other thing that's going on here is, these, I think, at least by one measure, are the most aggressive recess appointments imaginable. Because, one way of thinking about the recess appointment is, what do you get when you get a recess appointment? You get to serve during that session of Congress and then the following session of Congress. And these appointments were made, I don't think by accident, on January 4th, if I have that right. Mm-hmm. And, that was the day after Congress, the Senate and Congress and the House, I guess both, but the Senate in particular, met on January 3rd in a pro forma session to open up the new session of Congress. And so the administration's position is, that pro forma session, that was okay. That started off the new session. And that actually started the clock for the new session. Now, the next day, we're going to make this appointment, and we're going to, basically try to get a 2-year appointment out of the recess clause. And, I was involved in, I've not been involved in the Noel Canning case, but I was involved in a similar challenge earlier. And we kind of looked up what's the average tenure of an executive branch official. And it's just a hair over 2 years. So this is a very aggressive use of the recess clause. There's a debate about how long the recess here is, but part of the government's theory is that any recess will do. So even if the pro forma sessions are okay, it would be against sort of the historical tradition, but any recess will do. And I think what's happened here is that the very aggressiveness of this position has, I think it initially caused people to think, well, come on, you can't do that, because if you look historically, people have always kind of understood that, kind of 9 days is pushing it and 3 days is completely, nobody thinks you can have a 3-day recess appointment. But then when you start looking at the materials and try to figure out, how would you go about drawing a line between 3, 9, 21, August, I mean, it's a mess.
Right.
And I think what happened in the D.C. Circuit is, even though the parties might have first wanted him to try to draw a line between, a very sort of aggressive kind of 3-day recess appointment or something, or focus on the pro forma, once you start looking at the materials, it kind of pushes you to one extreme or the other, which is kind of either anything goes, or, hey, wait, it's only an intersession recess and only a vacancy that happens. So I think, I don't have a good prediction as to how the court's going to deal with this, but I think that dynamic, that it's not that easy to, come up with a Goldilocks solution here and say, as long as you wait 11 days, it's great, but 3 days is not really a recess or something. I mean, that's just very hard for the court to find that, and it may actually push them toward one extreme position or another. And certainly, I think some justices will react differently. I could see Justice Scalia, for example, more of a textualist, really be attracted to one of more of the polar views, and it may be very hard to find 5 justices in the middle to cobble together a solution.
Yeah, no, I think the president, he certainly picked a fight, and if he loses, he may end up weakening the office. Well, let's move on and talk a little bit about McCutcheon versus FEC. So, Paul, 3 years ago, the court had a big blockbuster case, Citizens United, dealing with the constitutionality of certain campaign finance laws, and now that issue is back before the court again. What's this case all about?
Sure. Well, at one level, this case is about the ugly underbelly of campaign finance reform, the part of the statutes that look more like tax law than they do like First Amendment law. But from, I think in some ways the real question here is this case going to be another Citizens United, or is this going to be a fairly kind of, just by the facts type, as applied almost type decision? So what's at issue here are the constitutionality of the so-called aggregate contribution limits. And so I think we're all sort of, typically tend to be familiar with the idea that there's only so much an individual can give to a particular candidate. And there's only so much that an individual can give, say, to the RNC. But perhaps less obvious to people is, in addition to those kind of specific contribution limits, there's also an overall aggregate cap which limits how much an individual can give to PACs, the RNC, and candidates in any one particular cycle. And I think that in and of itself kind of creates the difficulty for the government in defending the aggregate caps, because Congress has made a judgment that you're not going to have a serious problem with quid pro quo corruption if you give X amount to a candidate. Let's say $5,000 to a candidate for a couple to give to a candidate or something. So if it's okay to give $5,000 to a candidate, and it's okay to give $5,000 to 9 candidates, why does it become problematic for somebody who's got enough money and enough interest to do it to give $5,000 to 10 candidates or 11 candidates? But it's at the point that they start giving that kind of larger sums that they bump up against the aggregate cap. And so, and a similar analysis would apply to the caps that apply not just to the candidate elections, but to the RNC and the like. So if it's okay to give whatever the current number is, $50,000 to the RNC, and it's okay to give $5,000 to 9 candidates, why is it not okay to do both of those things at once? Why at a certain point do you have to pick and choose? And so I think there's a way for the court, if they're skeptical of this, and I think the past couple of terms have showed that there are 5 justices who tend to be fairly skeptical of campaign finance limits. I think that if they're skeptical about this, I think it's going to be easy enough for the court to rule narrowly and essentially use Congress's own justification against it. Why, if you have limits that presumably deal with the problem of quid pro quo corruption, what's the additional justification for this overall aggregate cap? And I think that's a hard argument. The government, in response to that, says, well, in about 6 sentences in the 112-page Buckley opinion, the court said that aggregate caps were okay. And so there's this sort of stare decisis aspect of the case. The real problem with the government with that argument, though, is that at the time that those aggregate caps were approved in Buckley, there were no limits on certain PAC contributions and RNC contributions. So you could almost think that at that time the aggregate caps operated in lieu of more specific caps on contributions, say, to a national political committee. But now that you have basically all the constituent parts with their own limits, I think the justification for having an aggregate limit at that point is much more difficult. The other thing the government says is, well, there's an anti-circumvention rationale. And part of the problem with that, again, though, is that the campaign finance statutes actually sort of make more sense than some people give them credit for. There's an independent prohibition on what's called coordination. So if you're trying to circumvent one limit by, say, giving money to the RNC so they can give it to your preferred candidate, and that's the way you give $20,000 to your preferred candidate instead of 5, that's already prohibited. So this is kind of, to use a phrase that the Chief Justice used, I think in Citizens United, there is a sense in which this is prophylactic on top of prophylaxis. And it's going to be, I think, for that sense, harder for the government to justify this than some other provisions in the campaign finance. Now, all that said, precisely because the government is relying on Buckley, there is the possibility, and certainly both one of the parties and Senator McConnell as an amicus have argued that, hey, if Buckley's at issue, bring it on. Let's talk about the stare decisis value of Buckley at this point in our history. In particular, let's talk about whether it really makes any sense to treat contribution limits fundamentally differently from expenditure limits, which is the regime of Supreme Court review we've had in place since Buckley.
Do you see the court accepting that invitation, doing a broader, taking on Buckley in that way?
I think I think in some ways it will come down to the Chief Justice, because there are at least 3 justices, Justice Scalia, Justice Thomas, and Justice Kennedy, who are pretty much on record as kind of being willing to fundamentally reconsider Buckley, and particularly whether it really makes any sense to treat contributions and expenditures differently. I think there's no question that Justice Scalia and Justice Thomas are there. I think Justice Kennedy, you could read a couple of opinions a little bit differently, but I think probably the best way to read his opinions is he's also there. On the other hand, the Chief Justice, I think, has had an interest in this area at times to move slowly and at times to move more boldly. I mean, you can go back to in the cosmic scheme of things, a relatively obscure case called Wisconsin Right to Life, where the Chief Justice and Justice Alito broke from Scalia, Thomas, and Kennedy and wrote kind of more narrowly to strike down the particular application of the campaign finance laws, but not kind of get to the big question. Then in Citizens United, the Chief Justice was more willing to kind of, go address the big question. And so I think those are the paradigms that are out there. I guess I'm inclined to think, though, that the court and the Chief Justice might be a little more likely to rule narrowly here, just because I think there is like I said, I do think the aggregate caps are difficult for the government to justify. So it may be a situation where they don't really need to reach out for the big thing. The one thing that cuts the other way is, as I mentioned, Senator McConnell did argue this kind of broader position to overrule Buckley, and they did give Senator McConnell argument time. So you could read into that just deference to the minority leader's views, or you could read into that, boy, they're really interested in hearing at least somebody get up there and say, let's swing for the fences in this case.
Any other thoughts before I move on to the next case? All right, well, John, last term the court took up a racial preferences case in the Fisher case. Now it seems that racial preferences are coming back before the court in a very unusual case, which is Schuette versus Coalition to Defend Affirmative Action. And this case involves something called the political restructuring doctrine. So what is this case all about?
Well, the state of Michigan, by initiative, adopted a constitutional amendment that provides that all public universities and school districts, quote, shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin, unquote, in public employment, education, or contracting. And the Sixth Circuit en banc struck it down under kind of unusual circumstances in that two of the more conservative judges, George W. Bush appointees, recused themselves because they have ties to universities that have affirmative action programs. I think they're on the boards or something. And a relatively liberal judge, a Clinton appointee, whose senior was allowed to sit on the en banc because she had served on the panel under the rules, and still it was only a one-vote margin. I think that the outcome may also have struck some people on the court as a little bit crazy, because you're taking a law that facially prohibits discrimination, and what the Sixth Circuit did is they applied this political restructuring doctrine, which is a form of basically anti-discrimination law, saying that adopting the process was itself discriminatory. And I think that probably strikes some people as crazy when you say, when you read it textually. But I have to commend whoever came up with it, because I'm not sure that a lot of people know political restructuring doctrine, even of the cases. The court has only gone to it, or only held on this ground twice, once in 1969 and once in 1982. The first case is Hunter versus Erickson, and I think that this is a much more appealing case. It gives you an idea behind it. And the idea is that you're basically disadvantaging a minority by singling them out and saying only this kind of thing is going to be decided in some way, only this type of issue is going to be decided in a way that's harder for you to affect, or that's harder for you to take care of. And what they had there was that in that case, you needed essentially voter ratification of any housing discrimination law. So before the city council could say you can't prohibit racial discrimination in housing, you have to have it adopted by referendum. And the court there held 8-1 in an opinion by Justice White, who I didn't think, at least of as a fire breather, that you're reaching out to disadvantaged minorities there, and you can't do that by making it harder for only them essentially to change the political process. The second case, and this is I think the weak precedent when I said that the kind of organizing theme in Buckley versus Vallejo, although Buckley stands for everything at some point, is also parts of it I think are weak precedents, is Washington versus Seattle School District, which held essentially the same thing by a 5-4 margin about a law prohibiting busing for racial balancing. There are people in this case, there are parties in this case that are swinging for the fences and saying the court ought to abrogate political restructuring doctrine. Chuck Cooper has filed a brief on behalf of a respondent supporting petitioner, because as you may know, everyone who's not a petitioner in the Supreme Court is a respondent, meaning that some respondents get to file reply briefs, which, let me tell you, sucks when you are on the bottom side and you have to respond to other red briefs and additional yellow briefs, reply briefs. But there are, in this case, also many different off-ramps that the court could take. They could say, they could strike down just or abrogate just the Seattle School District number 1 case by saying, we didn't appreciate at the time that busing was constitutionally suspect. They could limit the restructuring doctrine so that it doesn't apply in instances where all you're doing is facially requiring non-discrimination. There are a bunch of different ways to skin this particular cat.
So I assume that you saw this effort in the lower court as sort of an attempt to get around Fisher by enshrining or taking away from the people the right to have equal application of the laws and allow lobbying or that kind of political pressure.
Right.
And so the court is going to take that avenue out.
That is true. I mean, it is kind of an interesting alternative way that they could approach this. But that's one thing that is kind of interesting about this case is that either way this comes out could have much bigger implications because, say they uphold it at the moment, or rather if they say Michigan's right and they say that the political restructuring doctrine doesn't apply here, it could have, very big implications because at the moment only Michigan and California have adopted statutes like this, but you could definitely imagine there being kind of a referendum process where state after state adopts a similar thing because it's obviously very appealing proposition to vote for. And on the other hand, if the court says no, that the Sixth Circuit was right, it could kind of say that the political process doesn't even affect such a basic thing, saying no, you can't adopt, you basically can't restate the 14th Amendment in your own Constitution's law because, at least if you limit it to particular areas, because it looks like you're being discriminatory.
Well, we got started a little bit late, so we'll stay a little bit late because I want to cover one other case before we get to your questions, which is, so Paul, the politics of abortion are back before the court in McCullen versus Coakley, and this is a constitutional challenge to a Massachusetts law that creates a buffer zone around abortion clinics. And back in 2000, the court kind of dealt with this issue in a case called Hill versus Colorado, but the composition of the court has changed dramatically since then. You have 4 of the people who were in the majority that upheld that regulation are now off the court. The 3 dissenters are still on the court. So what's this case all about?
Well, just in the briefest terms, I mean, I think you set up the case very well. It's about a Massachusetts statute that limits the ability for there to be sort of approaches of individuals within, a certain number of feet of a facility, and the facility is defined not just to include sort of any healthcare facility, but is defined in more targeted terms to, it's not sort of targeted at abortion clinics per se, but it's targeted to sort of, I forget the statutory term, but like, health services
Healthcare
providing reproductive services or something like that. So that allows the court, if it wants to distinguish this 2000 case, Hill against Colorado. And I think in some respects that, as with some of these other cases, the way to think about this case is there's an opportunity for the court to rule boldly. There's an opportunity for the court to rule quite narrowly. This is, in some respects, you can think of this as an abortion case, but you can also think of this as a free speech case. And I think if you look at the opinion that Justice Kennedy wrote in Hill against Colorado, I mean, I think he will think about this as primarily a free speech case. And when Justice Kennedy thinks about a case as a free speech case, he tends to vote in favor of the First Amendment, not against the First Amendment. So I think you have sort of, the dynamic here where, Justice Kennedy and presumably, some of the other sort of loosely speaking conservative justices are going to be attracted to the free speech aspects of this case. And the question may well come down to, are they inclined to overrule Hill against Colorado, or are they inclined to distinguish Hill against Colorado, because there are enough sort of factual differences between the Massachusetts statute at issue here and what was at issue in Hill against Colorado, that they could just sort of say this doesn't come within the terms of Hill against Colorado, or they could rule more boldly and essentially say that Hill against Colorado should be overruled.
You had Kennedy and Scalia and Thomas as the dissenters in Hill Colorado. Yeah.
Exactly, and they're still around.
Yeah.
There's two considerations here, I think, that point in slightly different directions. One that may cause them to want to rule kind of narrowly is, you may remember, I think it's about 2 terms ago now, they had one of these funeral protest cases. And, that's kind of, to the extent that, the conservatives on the court might be pretty sympathetic to protesters at abortion clinics. They might be less sympathetic to protesters at military funerals. And so, one way to kind of rule narrowly, having that other case kind of fresh in their minds might cause them to want to rule a little bit narrowly, in the other direction. There's some cases where you can distinguish a prior precedent and you cannot in any way sort of add to its force. But I think here, to distinguish Hill against Colorado in ways that focused on sort of the breadth of the healthcare institutions that are covered by the 2 statutes or the size of the buffer zones, it's hard to do that without almost kind of reinforcing sort of Hill against Colorado. And so it may be that Justice Kennedy and others don't want to distinguish Hill in a way that leaves it a stronger precedent than it was before.
Any other thoughts before we open it up, John?
No, other than to say it is true that this is going to be a tough question for the court to try to figure out what to do with this, because the fact of the matter is that Justice Kennedy really is not a big fan of Hill versus Colorado, and the way that he normally, there's certain groups of precedents that I don't think he he's not getting over them. And I'm not giving you any internal information because I clerked before the Hill term, but I think that falls in that category that where he doesn't want to cite it because he doesn't want to give any indication that he agrees with it. And so it will be interesting to see what happens with it, because there are plenty of ways to distinguish this. This is much more easily struck down statute than the one in Hill. But that is the question about whether or not you want to leave that edifice up there.
Well, I think we'll open it up for a remaining 10 or 15 minutes for questions. We have microphones in the back, so if you'd like to ask a question, please raise your hand. We'll be happy, of course, to consider you as a panelist for a future program, but today is not that day, so I would ask you not to make a speech, but to limit yourself to just asking a question. You have one hand over here.
Hi, Peter McCaffrey from the Frontier Centre. It's a think tank in Western Canada. Is this working?
You might want to speak up a little bit.
Okay. Peter McCaffrey from the Frontier Centre. It's a think tank in Western Canada. I'm a policy person rather than a lawyer, so if I can ask you a couple of maybe clarifying questions on a couple of things you discussed. On bond, you mentioned the old case. I haven't got it in front of me now.
Missouri v. Holland.
That's it, yeah. If that were... Are you essentially saying that under that, if, say, the President was to sign a treaty with the United Kingdom saying that both countries would exchange all private information about phone calls, emails, Facebook messages of all citizens with each other, that would then give the President the authority to collect all that information, regardless of what the Constitution and other laws say to prevent that? And on a second one, the NLRB case, the appointment, if it was to arise during a recess, the way it seems to be written, that would seem to give the President permission to fill that appointment at any time, even if Congress had gone back into session, if it were to arise during that time. Maybe I'm reading it wrong, maybe there's some other language that isn't included in this part or it's been ruled on before.
Thank you for the question.
But it says arise.
Yeah, I'll take the first part of it, which is just to say, no, I think the theory of Missouri against Holland is that if there is a valid treaty, that then the implementing legislation doesn't have to comply with sort of the structural provisions of the Constitution. There's a subsequent case called Reed against Covert that suggests that the sort of affirmative prohibitions of the Bill of Rights, like the First Amendment, would still apply to the treaty itself and any legislation passed to implement the treaty. It's part of the reason why, though, I think the government's argument. I'm biased. I represent Ms. Baum, but I think that the government's argument here is tough, because if you concede that the First Amendment and the Second Amendment constrain the treaty power and constrain legislation passed to implement a treaty, then it's a little harder to understand why structural provisions wouldn't constrain, especially when the Supreme Court, led by Justice Kennedy, has been quite emphatic that the whole reason that we have structural provisions in our Constitution is to promote individual liberty. And so, what the government wants to do is sort of say, well, there's the Bill of Rights stuff that, is individual liberty protecting, but the structural stuff, that's just, different, and that can be overridden in the treaty process. But I think in light of some of the Supreme Court's cases, including the first Bond case, that's a harder argument for the government to make.
And on the textual point, that is an ambiguity in the clause, but it's usually during the recess of the Senate has been held to apply to the fill up part, and that's the question: is how far back does that phrase "during the recess of the Senate" apply? Does it apply to just all vacancies that may happen, or does it also have extend all the way back to she'll have the power to fill up all vacancies that may happen? And I haven't heard anybody, or at least I haven't heard anybody, any of the parties advocate that the president could fill them at any time. The big battle is over, just what it means for the vacancy to happen during the recess.
Other questions? Got one in the back, Roger.
I'm Roger Clegg with the Center for Equal Opportunity, and I'd like to ask if you have any thoughts on the Mount Holly case.
I don't, Roger. You know this case much better than I do, probably. This is a case about, the extent to which there's going to be disparate impact claims under the Fair Housing Act, if I'm right so far.
Yep.
In some ways, I think the interesting question here is whether the case stays on the court's docket. Last time the court had, a case involving this issue, the case sort of went away. I've read some speculation in the press that this case too might go away, and it's one of these interesting dynamics where, I think all the circuits are on one side of this issue, essentially saying that disparate impact claims are covered, but there's, most court watchers think there may very well be 5 votes to say they're not. So, it's not clear. I mean, whether Mount Holly goes away or not, that kind of dynamic, I think, is going to make it difficult for this issue just never to get resolved, because you get all the, unless people just stop bringing these claims, because the circuits are all on one side that allows any petitioner who wants to bring up this issue to what looks potentially to be a sympathetic court.
Since you all are practitioners, maybe I could follow up by asking, at what point does a settlement of the case become unseemly? That is, suppose that the case had already been submitted, had already been argued and submitted, and just before the court was about to issue its opinion, the parties announced that there was going to be, that they'd reached a settlement. Is the court still obliged under those circumstances to stay its hand?
I actually think it's a fascinating question, because what it gets to is really the nub of something that's very distinct about the Supreme Court of the United States versus every other court, which is, we all know that the Supreme Court takes cases not just because they want to deliver justice in that individual case, but because they're trying to decide some broader issue that has either split the circuits or is of surpassing importance. And yet, at the same time, we all know that's why they're taking these cases. The vehicle for deciding those broader issues of surpassing importance remains the individual case. And, as a lawyer in one of those individual cases, you don't have, your first obligation is to your clients in that individual case, and not necessarily to doing everything in your power to sustain that, the case so that they can decide the broader issue. And there is a tension there, because, you're there defending a client. I had a case a couple of years ago that settled after oral argument. I represented some, plaintiffs who were trying to get compensation, and after the argument, they got offered a whole lot of money. Now, the consequence of them taking that settlement was that the Supreme Court couldn't decide the case that they had granted cert to decide. The consequence for my clients were, after being wrongfully imprisoned for several decades for the first time in their lives, they had some money. So it just shows that, there is, I don't know what the answer is, but there is this kind of tension there, which is, on the one hand, by taking, that very favorable settlement, after an argument that seemed to go pretty well for them, they both deprived the court of the opportunity to decide the case, and frankly, deprived, the next litigant of a Supreme Court precedent that might have been very helpful to them. But, particularly in that case, given that they'd spent about, 20 plus years in the Iowa penitentiary, it was pretty hard to begrudge them. Now, not every case is the same, but I just sort of highlight the tension to show why I think it is really kind of a difficult issue.
This is the sad thing, is that especially in private practice, you actually have to work for your clients. But I actually have a case now that a petition pending now where we filed this, and the government actually made a settlement offer based on our petition. And it's kind of a tough deal because it's a really cool issue, and we got a bunch of amici lined up and so forth. But to give you some actually pertinent information, there was an opinion, I think last year, Justice Alito's opinion in the union case, and I'm becoming more and more like Justice Kennedy in that my descriptions are becoming ever vaguer. But Justice Alito said basically, we take a dim view of when parties try to moot cases after we've taken them, because they're afraid of what we might say. And that case, I think a settlement is pretty hard to say that there's still a live controversy after, both parties are fine with it. But when, where it's kind of more of a marginal question, Justice Alito suggested that they would take a dim view and they might sort of err on the side of keeping the case around if it wasn't entirely clear whether the case was mooted out. And of course, that's about all I remember about that case, so I can't give you any more useful guidance.
Anything else? Yes, Roger. I'm afraid this will have to be the last question.
Pilon with the Cato Institute. Paul spoke a moment ago about his case in which we all know what happened. Well, we all know, I'm going back to Noel Canning, probably for you, John. We all know what happened there, and namely the vacancies happened when Congress was in session. The filling of them happened when it was perhaps in session or not. But the language, it seems to me, of the Constitution, the text is pretty clear. The vacancies that happen when Congress is not in session, here Congress was in session. Why do you think the court has had such a hard time reading the language for what, at least on a common sense view, it plainly says?
Well, you're always in trouble whenever you appeal to common sense with a lawyer. But I do think that this is happens where the vacancies happen. I think the most intuitively and most natural reading of the statute is that the vacancy has to arise during the recess. But that said, there's a fair amount of practice going a long way back. The government's has research, suggests that it definitely extends back to the founding era. And that Jefferson, even though he talked a good game, may have made appointments that violated that. It is striking, it is noteworthy to me, having looked at the documents. They're very hard to trace back because it's hard to figure out when people died or resigned. But it is striking how little they seem to care about when they died or resigned, which itself may be telling. And I think that there is, as a former lawyer to the president, there is, sort of a tendency that if there is a good faith argument to be made that gives the president the power to address, something that is a problem, that you make it even if it isn't necessarily the first thing you would think when you're looking at it. Like, for example, especially in an era of bad communication, it seems like a bad idea that if you haven't heard, or that, if somebody dies the day before the Senate goes out, and you find out while the Senate's out, well, the vacancies there are just the same. And they took those things very seriously back in an era before the Vacancies Reform Act, and business just wasn't going to get done. And so they might think that would the founders really have meant for that kind of strange set of affairs, that strange circumstance to go unremedied. So Anyway, that's my argument for perhaps the less textually appealing answer, without saying I necessarily embrace it.
Well, gentlemen, I know you both have cases before the court this term, so best of luck. Thank you all for attending. This has been a great session. Please join me in thanking